Order. The clerk will now proceed to read the orders of the day.
Item 1, the Supreme Court of Judicature Amendment Bill, Amendment Number 2 Bill, second reading.
Minister for Law.
On behalf of the Minister for Law, I beg to move that the bill be now read a second time. Sir, the Supreme Court of Judicature Amendment Number 2 Bill introduces amendments to achieve two desired outcomes. First, it seeks to streamline court procedures to enhance efficiency, introduce flexibility in order to meet shifting trends, and also accommodate the needs of individual cases. And secondly, it empowers the courts to better manage vexatious or tardy conduct in proceedings. In the main, the proceedings will allow courts to operate more effectively and efficiently without compromising access to justice. This ensures that judicial resources are better allocated and results in time and cost savings for litigants and lawyers alike. I will now take the House through the key features of the bill. Technology has significantly changed the way we live and conduct our affairs. With the advancement of technology, we are able to accomplish tasks in a much faster and efficient manner. Similarly, if used meaningfully, technology has the ability to also make a positive impact on the way our courts function. Clause 2 of the bill therefore provides that courts can conduct hearings via electronic means, such as live video link or live television link. Previously, apart from the provision of evidence by witnesses in civil proceedings, the law did not provide for the general conduct of hearings through electronic means. With this amendment, legal proceedings which do not require the physical presence of parties or their lawyers in court can be conducted quickly and more efficiently via electronic means. This enhances the court process and saves time. The bill also grants the court various powers so that they can swiftly dispose of cases in the most appropriate manner. Let me touch on a few of these provisions. First, Clause 6 of the bill expands the range of cases that can be decided based on written submissions. At present, the Court of Appeal may decide any application for leave to appeal based on written submissions. Under this provision, it is now proposed that the Court of Appeal can determine any application, and two, in circumstances where the parties consent, appeals from the Singapore International Commercial Court based on written submissions. The amendment only empowers the Court of Appeal to decide any application to it without hearing oral arguments. So an application as in contrast to a substantive appeal. The scope of this amendment does not extend to cover other substantive appeals except for those which emanate from the SICC, and even then in situations where the parties agree. Where the Court of Appeal is of the view that even with this power, oral arguments are necessary, then it will continue to retain the power to and will in fact hear such oral arguments before deciding the application or appeal. Second, Clause 7 empowers the Court of Appeal on its own motion to summarily dismiss certain matters in two situations. First, where the court lacks jurisdiction to hear and determine the appeal or application. Or second, where there is no merit in the appeal or application because the issue has been decided by the Court of Appeal in an earlier matter in which the appellant or the applicant was involved. This clause allows unmeritorious appeals or applications to be dismissed without expending unnecessary judicial time and resources. However, safeguards are put in place to ensure that the interests of the applicant or the appellant are adequately protected. In this regard, before a court can summarily dismiss an appeal or application, it must give the appellant or applicant a reasonable opportunity to show cause as to why the appeal or application should not be dismissed and consider the representations of the appellant or applicant. Next, we are also proposing amendments in relation to the admission of further evidence on appeal. At present, further evidence can be admitted on appeal without leave of court. One, in relation to interlocutory applications, and two, where the matters occurred subsequent to the date of the earlier decision. In line with efficient judicial administration, parties should be encouraged to present all relevant evidence at the first instance hearing so that the cases can be disposed of fairly, efficiently, and also comprehensively based on the available evidence. This is of course with the exception of matters or evidence which occurred after the date of the decision as parties would not obviously have known about it. Therefore, in this vein, Clause 9 of the bill proposes that leave of court would be required before an application can be made to admit further evidence on appeal, except for matters which occurred subsequent to the date of the decision. This means that parties who seek to admit further evidence on interlocutory applications will now require leave of court in order to do so. This will ensure that only meritorious applications to adduce further evidence will be allowed to proceed. In the same vein, Clause 8 introduces a new requirement for leave of court to make an application to discharge or vary incidental directions or orders made by the court under Section 36 of the Act. This is in respect of directions or orders which are ancillary to the main appeal and are unlikely to touch on the substantive merits of the case. The requirement for leave of court ensures that court resources will be directed appropriately to deal only with meritorious applications to discharge or vary. In deciding whether to grant leave or not for a party to vary or discharge a direction or order under Section 36, the Court of Appeal will consider if such directions or orders are in fact ancillary to the appeal or whether they in any way go towards the merits of the appeal. Leave would be granted where it would be in the interest of justice to do so. Next, the bill also seeks to introduce flexibility and efficiency in the court process to allow for cases to be heard expeditiously and also have regard to the various shifting trends that may arise. In this regard, clauses 4 and 5 of the bill introduce amendments to allow for matters relating to, firstly, the quorum of the Court of Appeal, and secondly, as to which matters are non-appealable or only appealable with leave of the Court of Appeal, or rather leave to the Court of Appeal, I beg your pardon. And the proposal is to move these items from the primary act into the 4th to 6th schedules. As to the quorum of the Court of Appeal, Section 31 of the Act states that the civil jurisdiction of the Court of Appeal shall be exercised by 3 or any greater uneven number of judges of appeal. Section 32 sets out the types of matters which can be determined by a Court of Appeal consisting of 2 judges of appeal. Clause 4 of the bill will seek to introduce a new 6th schedule which would set out the number of judges that will be required to exercise the civil jurisdiction of the Court of Appeal for different matters as specified in that schedule. The members can be assured that when the matters are moved into the 6th schedule, they will continue to reflect the current position that is based on Section 30. As regards appeals on certain matters, the current Section 34(1) and the 4th schedule sets out matters which are non-appealable to the Court of Appeal, while Section 34(2) and the 5th schedule set out the matters which are appealable only with the leave to the Court of Appeal. By Clause 5 of the bill, matters which are non-appealable will now be set out in the 4th schedule, and matters which are appealable only with leave will be set out in the 5th schedule. So part of the amendments seek to consolidate all the items into one schedule, rather than have them appear in parts of the bill and in the existing schedule. The only exception to this would be Section 34(2)(a), which sets out the jurisdictional monetary limit and threshold. This, because it deals with question of jurisdictional monetary limit, will remain in the Primary Act. These amendments allow for quicker revision of each of the above categories, as amendments of the primary legislation would require more time to effect rather than the amendment of the schedule itself. Placing these matters in the schedules therefore allows for more flexibility and speed, as they can be amended by the Minister in consultation with the Chief Justice. The schedules can be revised swiftly to ensure that an efficient allocation of judicial resources can be balanced against the volume of appeals, so that the Court of Appeal can handle deserving cases expeditiously. Let me touch on 2 further amendments in relation to, firstly, the monetary thresholds for appeals from the district and magistrates' courts, and secondly, the Rules Committee being empowered to make rules relating to the manner in which evidence is to be adduced. On the first point, Clause 3 increases the monetary threshold to 60,000 for decisions of the districts and magistrates' courts which are appealable with leave to the High Court. At present, as some members may know, decisions of the district and magistrates' courts are appealable to the High Court with leave if the amount does not exceed 50,000. However, the jurisdiction of the magistrates' court is set at 60,000, which means that there are cases with claim values of between 50 and 60,000 which would be appealable to the High Court without leave. The proposed amendment just seeks to ensure consistency and provides that there will be no automatic right of appeal for cases that fall within that 50 to 60,000 range. Second, as to the second point I raised earlier, Clause 14 seeks to clarify that under Section 80, subsection 2H of the Rules Committee is empowered to make rules relating to the manner in which factual, expert, or opinion evidence is to be presented in court. I turn now to the next basket of amendments that deal with vexatious proceedings and tardy conduct in the legal proceedings. Vexatious litigation is a drain on our court resources. They draw away precious court time from dealing with meritorious applications. The Court of Appeal has had the opportunity to define vexatious proceedings in recent case law, and these amendments do not seek to change that. Broadly, vexatious proceedings are those which are groundless and without merit. They may be initiated with the purpose of annoying or embarrassing the other party, and not for the purpose of having the court decide on the issue. Apart from wasting judicial resources, vexatious conduct, especially when instituted habitually and persistently, cause distress and annoyance to the other parties to the proceedings, as they are the subject of a litany of baseless lawsuits and applications. At present, Section 74 of the Supreme Court of Judicature Act provides the only recourse against such vexatious litigants. If a party has habitually and persistently and without any reasonable grounds instituted vexatious legal proceedings in any court, it is the Attorney General who has to make an application to the court to restrain such conduct. And upon the making of such a successful application, the High Court may then order that either no legal proceedings be instituted by that party without the leave of court, and or any legal proceedings instituted by that party in any court before the making of the order shall not be continued by him without leave. This current approach is limited in two ways. First, the court and the affected party have no power on their own to apply under Section 74, regardless of the degree of the vexatious conduct, the impact it may have had on the affected party, as the application must be made by the Attorney General. Second, Section 74 carries with it severe consequences and may not be proportionate to or properly calibrated to meet the mischief in question in all cases. To address these limitations, Clause 10 of the bill introduces a new power to allow the courts to make three different types of civil restraint orders to address varying degrees of vexatious conduct. The three different types of orders are as follows. Firstly, a limited civil restraint order. This order may be made against a party who has made two or more applications that are totally without merit. The party will be restrained from making further applications in the particular proceedings in which the order is made without the leave of court. Second, an extended civil restraint order. This order may be made against a party who has persistently commenced actions or made applications that are totally without merit. The party will be restrained from commencing any action or making any application concerning any matter involving, relating to, or touching upon or leading to the proceedings in which the order is made, without the leave of court, for a period not exceeding 2 years. Finally, a general civil restraint order. Such an order may be made against a party who has persisted in commencing action or making applications that are totally without merit, and in circumstances where an extended civil restraint order would not be sufficient or appropriate. The court, or rather the party, will be restrained from commencing any action or making any application in any court specified in the order without leave of court for a period not exceeding 2 years. This gradated approach gives more nuance in managing vexatious litigants, taking into account the specific facts of each case. The court will also be empowered to stay vexatious proceedings and order that no further documents be filed by a party if the filing of documents would be vexatious or otherwise for an improper purpose. Under the proposed amendments, the High Court or the Court of Appeal may make these orders, one, on its own motion, which it presently cannot do, two, on an application by a party, again, which it presently cannot do, or three, on an application by the Attorney General, which is the current position envisaged under Section 74. Before an order is made against a party, that party will be given an opportunity to be heard by the court. In relation to proceedings before a lower court, a party or the Attorney General may make an application to the High Court for one of the above-mentioned orders. So to the extent that this may appear in the district courts or the magistrates' courts, application is made to the High Court. This power ensures that the High Court can also make the necessary orders to address vexatious proceedings occurring before that lower court, and it would be more appropriate for the High Court to make such orders instead of the lower court, because the impact of such orders are potentially far-reaching and restrains a party's ability to conduct legal proceedings. The party against whom an order is made may bring an appeal to the Court of Appeal with the leave of the High Court or the Court of Appeal. Similarly, Clause 11 amends the existing Section 74 such that a person against whom an order is made under that section may appeal against the order with the leave of the High Court or the Court of Appeal. These new powers were drawn from best practices in the UK and Canada. In moving from a single touch point for vexatious proceedings under Section 74 to a gradated approach, courts are now better equipped to manage the varying degrees of vexatious conduct. This accords with the notions of fairness and also proportionality, as litigants are restrained to different extents based on the severity of their vexatious conduct instead of a one-size-fits-all approach that is currently the regime in Section 74. Finally, I'd like to touch on some revisions to the imposition of late filing fees for non-compliance with the rules of court. In addition to the powers to manage vexatious proceedings, Clause 16 of the bill also ensures that efficient disposal of cases, ensures the efficient disposal of cases by allowing the courts to impose late filing fees for non-compliance with rules of court, court orders or directions and practice directions. Currently, there are no automatic sanctions against the late filing of documents, and this tends to delay legal proceedings. These late filing fees seek to encourage parties and their lawyers to comply with the rules of court, court orders and practice directions in relation to the filing of documents so that legal proceedings can be conducted and completed in a timely manner. Sir, in summary, these amendments are part of our continuing efforts to improve civil procedure in court proceedings in Singapore. This is an ongoing and worthy endeavour, for it has often been said, and in my view correctly, that procedure is the handmaid of justice. By enhancing our court processes and strengthening court procedures, while at the same time ensuring that the interests of litigants are safeguarded, these amendments will enable the courts to continue to fulfil their mission of providing a just, efficient and effective avenue for all its users. Mr. Speaker, I beg to move.